important to have legal awareness for yourself, your family, and those around you. Hello, I'm Prachi Pratap. Welcome to my channel. Today, we will talk about dying declaration. Recently, I participated in a discussion on dying declaration. It was a case of dowry killing where a woman was set ablaze by her husband and in-laws. The discussion revolved around admissibility of dying declaration as it was recorded on video, yet there was a delay in action by the police. Let's discuss dying declaration, which is often the single piece of substantial evidence in many cases of dowry killing. Sati was abolished, but the cases of women being set ablaze is still on the rise. Section 32, subsection 1 of Indian Evidence Act defines dying declaration as a statement, written or verbal, of relevant facts made by a person who is dead. It is the statement of a person who had died explaining the circumstances of his death. Dying declaration is based on the maxim, a man will not meet his maker with a lie in his mouth. Nemo moriturus presumitur mentir. Matthew Arnold said, truth sits on the lips of a dying man. The law presumes that a dying person will not lie. In Maddox versus United States, Maddox 1 explained the policy of a declaration in articulo mortis, which is a declaration at the moment of death. The court opined that the certain expectation of almost immediate death will remove all temptation to falsehood and enforce as a very strict adherence to the truth, as the obligation of an oath could impose. However, the critique of dying declaration is highlighted by the Supreme Court of the United States in Carver 2, where it is mentioned, dying declaration by no means imports absolute verity. The history of criminal trials is replete with instances where witnesses, even in the agonies of death, have through malice, misapprehension, or weakness of mind made declarations that were inconsistent with the actual facts. There are always two sides of every case, and here we will understand verity of a dying declaration and treating it as an important piece of evidence. In Lakshman versus State of Maharashtra, the Honorable Supreme Court held that a dying declaration can either be oral or in writing, and that any adequate method of communication, whether the use of words, signs, or otherwise, will suffice, provided that the indication is positive and definite. There is no requirement of law stating that a dying declaration must necessarily be made before a magistrate, and when such statement is recorded by a magistrate, there is no specified statutory form for such a recording. Certification by a doctor is essentially a rule of caution, and therefore the voluntary and truthful nature of the declaration can also be established otherwise. There are instances where a magistrate was not present and declaration was made to others, even in form of just a complaint to police officer. Let's look at another case. In State of Karnataka versus Sharif 2003, the Honorable Court held that there was no requirement of law that the dying declaration must necessarily be made before a magistrate. In the case of Paras Yadav and others versus State of Bihar, the Honorable Court held that lapse on the part of investigating officer in not bringing the magistrate to record the statement of deceased should not be taken in favor of the accused. The court further held that a statement of the deceased recorded by a police officer in a routine manner as a complaint and not as a dying declaration can also be treated as dying declaration after the death of the injured, and relied upon if evidence of the prosecution witnesses clearly establishes that the deceased was conscious and was in a fit state of health and mind to make this. Look at another case. In Bhagirath versus State of Haryana, upon receiving message from the hospital that a person with gunshot injuries had been admitted, a head constable rushed to the place. After making entry in the police register and after obtaining certificate from the doctor about the condition of the injured, the constable took his statement for the purposes of registering the case. It was held that the statement recorded by the head constable was admissible as dying declaration. In Mafabhai Nagarbhai Rawal versus State of Gujarat, it was held that a person suffering 99% burn injuries could be deemed capable enough for the purpose of making a dying declaration. The court opined that unless there existed some inherent and apparent defect, the trial court should not have substituted its opinion for that of the doctor. Where the trial court held that dying declaration was not possible as the victim had gone into a state of shock after receiving such high degree burns. In the light of the facts of the case, the dying declaration was found to be worthy of reliance, as the same was made truthfully and voluntarily. In State of MP versus Dal Singh and others, the court explained the legal position while awarding life imprisonment to a man and his parents for burning his wife to death. The victim alleged that her mother-in-law had poured kerosene on her and her father-in-law had set her ablaze. Her husband had closed the door while she was burning. In their plea, the accused contended that there were two statements of the victim, one recorded by an executive magistrate and another by an investigating officer in the form of an FIR. And there was contradiction as to who had set her on fire. The trial court held conviction can be based solely upon a dying declaration, provided that the same is found to be trustworthy. However, in the instant case, as the deceased had 100% burn injuries, she would not have, in all probability, been in a position to make a statement. Additionally, in the absence of a certificate provided by a doctor to the extent that she had in fact been fit enough to make such a statement, the said dying declaration could not be relied upon, as she had died as a result of such injuries on her person after travelling about 10 kilometers from the place of occurrence to the police station. The Supreme Court rejected all such arguments, stating one cannot be expected in such a physical condition to give exact version of the incident. On the issue can be summarized to the effect that it does not provide who can record a dying declaration, nor is there any prescribed form, format or procedure for the same. The person who records a dying declaration must be satisfied that the maker of declaration is in a fit state of mind and is capable of making such a statement. By maker of declaration, we mean the victim. Moreover, a doctor's certificate in respect of state of mind of the deceased is not essential in every case. The bench placed reliance on the dying declaration of the deceased who had suffered 100% burn injuries on the ground that the dying declaration was found to be credible. In Ram Bihari Yadav versus State of Bihar, it was held that the dying declaration need not be in the form of questions and answer. In some cases, we see that it is neither the format nor the length of dying declaration which corroborates, but the circumstances and evidence of the whole case point to admissibility of the dying declaration. Let's look at a recent case, Jayamma and another versus the state of Karnataka. The accused allegedly doused the deceased Jayamma in kerosene and set her on fire after a heated exchange of words. The Honorable Supreme Court held that the narration of events in the dying declaration was so accurate that even a witness in the normal state of mind cannot be expected to depose with such precision. Although it was stated that deceased was questioned by the police officer, yet the purported dying declaration is not in a question and answer format. There was sufficient evidence on record that the victim had been administered highly sedative painkillers. Owing to 80% burn injuries suffered by the victim on all vital parts of the body, it can legitimately be inferred that she was reeling in pain and was in great agony, and the possibility of her being in a state of delusion and hallucination cannot be ruled out. Therefore, the accused were acquitted. Now let's discuss another such case. In the case of Suraj Oza versus State of Bihar, 1980, it is ruled that merely because a dying declaration is a brief statement, it is not to be discarded. On the contrary, the shortness of the statement itself guarantees truth. In Sumit versus State, 2021, the Divisional Bench of Delhi High Court upheld the conviction of the accused husband under Section 302 of IPC, where the husband had set the wife ablaze. The bench observed, the dying declaration of a person by itself may be sufficient to find the accused guilty, and if the statement is reliable and credible, it does not even need to corroborate. This was based on the Supreme Court case of Kushal Rao versus State of Bombay. Now let's look at forms of dying declaration. The acceptable forms of dying declaration have evolved over the years, and acceptable forms include letters, gestures, and even a mix of languages. In Queen Empress versus Abdullah, 1885, the accused had cut the throat of the deceased girl, and because of that, she was not able to speak. So, she indicated the name of the accused by the signs of her hand. It was held by the full bench of Honorable Allahabad High Court that if the injured person is unable to speak, he can make dying declaration by signs and gestures in response to the question. In the case of the state of UP versus Hari Mohan, the victim wrote a letter to her father to take her home, otherwise her mother-in-law and brother-in-law would murder her, just 2 days before when the murder took place. Then in this case, the letter became the dying declaration given by the woman. Now let's look at another case. Mukesh and another versus State for NCT of Delhi, also known as the Nirbhaya case. The dying declaration by victim was recorded in 3 parts. Firstly by the doctor, second by the subdivisional magistrate, which was in detail, and last by the executive magistrate, where it was recorded with the help of gestures and nods, which was accepted by the Honorable Supreme Court as a valid dying declaration. A dying declaration is an important piece of evidence which, if found veracious and voluntary by the court, could be the sole basis for conviction. However, the court, while admitting a dying declaration, must be vigilant towards the need for compos mentis certificate from a doctor, as well as the absence of any kind of tutoring. In the above case, we notice that the victim's statement were recorded multiple times. This brings us to the point, what if there are more than one dying declaration? As we have already seen, there was more than one dying declaration. So in the cases of multiple dying declaration, what happens? In the case of Sandeep and another versus State of Haryana, the first dying declaration given to a police officer was more elaborate, and the subsequent dying declaration recorded by the judicial magistrate lacked certain information which was given earlier. After referring to the 2 dying declarations, the court examined whether there was any inconsistency between the two dying declarations. The court held that there was no inconsistency between the two dying declarations and no mention of certain features in the dying declaration recorded by the judicial magistrate does not make both the dying declarations incompatible. More legal awareness is needed as we often come across cases where women are still burnt alive and yet justice is denied because law related to dying declaration is not known to the common person. Thank you for watching my channel. I hope it helps you in understanding the cases, in understanding the law, and I hope it helps spread legal awareness and awareness about our rights. Thank you.